There's nothing quite like the wonderful feeling of being on paid vacation. Fortunately for people who work in Ontario, this is also part of our employment law. So what exactly does the law say about the right to vacation with pay under Ontario's Employment Standards Act? Before we dive in, remember, the ESA doesn't apply to every type of job. Be sure to watch our detailed video explaining which jobs fall outside its protections. Also, this video is for educational purposes only and does not constitute legal advice, and it is not intended to create a solicitor-client relationship. My name is Ryan Keeney, and I'm a lawyer in Ontario. Let's get into it. The right to vacation with pay is regulated by Part 11 of the ESA, and that part includes sections 33 to 41.1 of the ESA. Since the wording of these sections can unfortunately get super confusing, if I'm being totally honest, this video will explain each of these sections in simple terms. So anyone who is an employer or employee can easily understand the rules, assuming the job is in Ontario and the job is regulated by the ESA. Starting with Section 33, let's dive into the specifics of vacation entitlement according to Ontario's Employment Standards Act. Subsection 1 of Section 33 of the SA outlines the minimum vacation time employers must provide to their employees. It states that an employee is entitled to a minimum of 2 weeks of vacation after each year of employment if their employment period is less than 5 years. If the employee has been employed for 5 years or more, this entitlement increases to at least 3 weeks of vacation per year. Importantly, subsection 2 of Section 33 clarifies that both active and inactive employment periods are considered when calculating this entitlement. This means that time off due to illness, leave, or other reasons, where an employee might not be actively working, is still counted towards their employment period for the purposes of calculating vacation time. For employees who don't take their vacation in complete weeks, subsection 3 of Section 33 provides guidance on how to calculate their vacation days. If the employee has a regular work week, their vacation days are based on the number of days in that work week. If there is no regular work week, the calculation is based on the average number of days worked per week during the most recently completed vacation entitlement year. Finally, subsection 4 of Section 33 deals with the transition to the new vacation entitlements that came into effect after December 31st, 2017. It clarifies that employees with at least 5 years of employment are entitled to at least 3 weeks of vacation for each entitlement year ending on or after that date. However, it does not require employers to provide additional vacation days retroactively for years that ended before this change. These provisions ensure that employees in Ontario have guaranteed time off, promoting work-life balance and overall well-being. They are an essential part of the employment standards that benefit both employees and employers by providing clear guidelines for vacation entitlements. Moving on to Section 34 of Ontario's Employment Standards Act, this section addresses the concept of an alternative vacation entitlement year. When an employer sets an alternative vacation entitlement year for an employee, different rules apply for calculating vacation time, particularly for what is known as the stub period. In the context of the Ontario Employment Standards Act, the terms alternative vacation entitlement year and stub period have specific legal definitions, and these definitions facilitate the calculation of vacation time and pay. An alternative vacation entitlement year is a 12-month period chosen by the employer that does not start on the employee's first day of employment. This period recurs annually and allows employers to synchronize vacation entitlements with their fiscal year or another standardized time frame separate from the employee's start date. The stub period, on the other hand, is a transitional time that connects an employee's start date or the end of their last standard vacation entitlement year to the commencement of their first alternative vacation entitlement year. This period ensures employees receive proper vacation time and pay for intervals that might not align with standard calculations, especially when the alternative vacation entitlement year begins either before or after the completion of the employee's first 12 months of employment. Understanding these definitions is crucial for correctly administering vacation entitlements in scenarios where the vacation entitlement year is not aligned with the employee's start date. For employees with less than 5 years of employment, their vacation for the stub period is calculated based on the ratio of the stub period to a full 12 months. If the employee has a regular work week, they are entitled to a vacation proportional to 2 weeks multiplied by this ratio. For those without a regular work week, their vacation time is calculated using the average number of days worked per week during the stub period, again adjusted by the same ratio. For employees with 5 years or more of employment, the calculation method remains similar, but the base vacation vacation time considered is 3 weeks instead of 2. This means their vacation for the stub period is more substantial, reflecting their longer service with the employer. Both active and inactive employment periods are included in these calculations, ensuring that all time employed, regardless of work status, contributes to vacation entitlement. The transition provision in subsection 5 clarifies that employers must provide vacation time in accordance with this section for any stub period ending on or after December 31st, 2017. However, for stub periods that ended before this date, there is no obligation to provide additional vacation days retrospectively. Moving on to Section 35 of the Employment Standards Act of Ontario, this section deals with the timing of vacation for employees. The employer is responsible for determining when an employee should take their vacation, but there are specific rules that must be followed. Firstly, the vacation must be completed within 10 months after the end of the vacation entitlement year. This ensures that employees take their vacation within a reasonable time frame after earning it. For employees who have been employed for less than 5 years, they are entitled to a 2-week vacation. This vacation can be taken either as a continuous 2-week period or in 2 separate 1-week periods. However, if an employee wishes to take their vacation in shorter periods, they can make a written request to their employer, and if the employer agrees, the vacation can be divided as requested. Employees with a period of employment of 5 years or more are entitled to a 3-week vacation. This can be taken as a continuous 3-week period, or it can be divided into a 2-week period and a 1-week period, or into 3 separate 1-week periods. Similar to employees with less than 5 years of employment, those with 5 years or more can also request to take their vacation in shorter periods if the employer agrees. In summary, Section 35 of the Act stipulates the timing and division of vacation time, offering some flexibility to employees while allowing employers to maintain control over the scheduling of vacations to ensure operational efficiency. Moving on to Section 35.1 of the ESA, this section addresses the scheduling of vacations when an employer establishes an alternative vacation entitlement year for an employee. This refers to a 12-month period starting on a date chosen by the employer, different from the employee's start date. The section stipulates that the employer is responsible for determining when the employee should take their vacation for the stub period. The stub period is the interval between the start of an employee's employment and the commencement of the first alternative vacation entitlement year. The vacation for this stub period must be taken within 10 months after the beginning of the first alternative vacation entitlement year. If the vacation entitlement amounts to 2 or more days, it is generally expected to be taken in a period of consecutive days, ensuring employees have a meaningful, uninterrupted break. In cases where the vacation entitlement is more than 5 days, at least 5 days of the vacation should be taken consecutively, with the option to take the remaining days in another consecutive period. However, the Act also provides flexibility. If an employee prefers to take their vacation in shorter periods, they can request in writing. If the employer agrees, the vacation can be taken in these shorter intervals. This flexibility accommodates different personal or work-related needs, allowing employees to utilize their vacation time in a way that best suits their circumstances. Moving on to Section 35.2 of the Employment Standards Act in Ontario. This section focuses on vacation pay. It specifies the amount of vacation pay an employer must provide to an employee who is entitled to vacation as per Sections 33 or 34 of the Act. The amount of vacation pay depends on the length of the employee's service. For employees whose period of employment is less than 5 years, the vacation pay must be at least 4% of the wages, excluding any previous vacation pay, earned during the period for which the vacation is given. This provision ensures that employees receive additional compensation reflective of the time they would have worked had they not been on vacation. For employees with a period of employment of 5 years or more, the vacation pay increases to at least 6% of the wages earned during the vacation period. This increase acknowledges the greater commitment and service of long-term employees. In summary, Section 35.2 ensures that employees are compensated for vacation periods, with the rate of vacation pay increasing as their tenure with the employer lengthens. This approach balances the needs of both employees and employers, providing a fair and scalable system for vacation pay based on the duration of employment. Moving on to Section 36, this part of the Employment Standards Act specifies the guidelines for employers regarding the payment of vacation pay to their employees. The Act primarily mandates that employers should pay vacation pay in a lump sum before the commencement of the employee's vacation. This rule is in place to ensure that employees have access to their vacation pay during their actual time off. However, there are situations situations where this can be handled differently. For example, if an employee's wages are paid through direct deposit, or if the vacation is not taken in complete weeks, then the employer has the option to pay the vacation pay on or before the regular payday for the period in which the vacation falls. This provides a level of flexibility, aligning the vacation pay with the regular payroll cycle. Another scenario allows for the vacation pay that accrues in each pay period to be paid on the regular payday for that period. This option requires the employee's consent and necessitates that the payment details be clearly outlined either in the regular wage statement or in a separate statement given at the same time. This ensures transparency in the payment of vacation pay. Lastly, the employer and employee can mutually agree to a different timing for the payment of vacation pay. This clause in the Act offers additional flexibility, accommodating unique circumstances or preferences in the employment relationship. In essence, Section 36 provides a structured yet adaptable approach to handling vacation pay, ensuring that employees receive their due benefits in a timely and clear manner. Moving on to Section 37, this section of the Employment Standards Act deals with the payment of vacation pay during a labor dispute. This section clarifies the employer's obligation regarding vacation pay when an employee's scheduled vacation coincides with a strike or lockout. Specifically, if an employer has already scheduled vacation time for an employee and a strike or lockout occurs during this period, the employer is still required to pay the employee their vacation pay. This payment is to be the same amount the employee would have received if the vacation had proceeded as scheduled. This rule ensures that employees do not lose their entitled vacation pay due to unforeseen labor disputes. Moreover, subsection 2 strengthens this requirement by stating that the obligation to pay vacation pay remains in effect despite any attempted cancellation of the vacation by the employer. This means that an employer cannot circumvent the obligation to pay vacation pay by simply canceling the scheduled vacation due to the strike or lockout. In essence, Section 37 provides protection to employees, ensuring they are compensated for their scheduled vacation time, even in the event of a labor dispute. This provision upholds the rights of employees to their earned vacation benefits, regardless of the circumstances surrounding a strike or lockout. Moving on to Sections 38 and 39 of the Employment Standards Act, these sections address specific scenarios related to vacation pay when an employment relationship ends and in the context of multi-employer plans. Section 38 focuses on the situation where an employee's employment ends. In such cases, if there is any accrued vacation pay owed to the employer is obligated to pay this amount. This payment should be made in accordance with subsection 5 of Section 11, which generally stipulates the timing and method for paying wages when employment ends. Essentially, this section ensures that employees receive all the vacation pay they have earned up to the termination of their employment. Section 39 addresses a different scenario involving multi-employer plans. Specifically, this section states that Sections 36, 37, and 38 do not apply to an employee and their employer if two conditions are met. Firstly, the employee must be represented by a trade union, and secondly, the employer must contribute to a multi-employer vacation benefit plan for the employee's vacation pay. In such situations, the standard rules for vacation pay outlined in the aforementioned sections are set aside in favor of the arrangements specified in the multi-employer plan. This provision recognizes the unique arrangements that can exist in multi-employer contexts, often governed by collective bargaining agreements or similar arrangements. In summary, these sections provide clarity on how vacation pay should be handled in specific employment scenarios, ensuring that employees' rights to vacation pay are protected, whether at the end of their employment or in a multi-employer context. Moving on to Section 40 of the Employment Standards Act, this section establishes important provisions regarding the handling of vacation pay by employers. Subsection 1 of Section 40 stipulates that all employers are deemed to hold vacation pay accruing due to an employee in trust. That might sound a bit confusing, so let me explain. This means that vacation pay is effectively separated from the employer's general funds and is specifically reserved for the employee. The requirement for employers to consider this pay as held in trust applies regardless of whether the employer has physically separated these funds in their accounting systems or not. Regardless of where the money sits, the money is legally considered to be trust funds. This provision ensures a level of security for the employee's earned vacation pay, highlighting its distinct and protected nature. At subsection 2 of Section 40, the legislation further strengthens this protection by stating that an amount equal to the vacation pay becomes a lien in charge upon the employer's assets. These assets are typically those that would be recorded in the ordinary course of business in the employer's books of account. Even if the vacation pay is not entered into the books, the lien still applies. This means that the vacation pay owed to an employee has a legal claim or hold over the employer's assets, providing an additional layer of security for the employee to ensure they receive their entitled vacation pay. In essence, these provisions treat vacation pay not just as another form of wages, but as a prioritized obligation of the employer, safeguarded in a way that aims to ensure employees receive this pay regardless of the employer's financial situation. Moving on to Section 41 of the ESA, this section addresses the conditions under which an employee can forego their vacation entitlement. Subsection 1 of Section 41 outlines that an employee may choose not to take a vacation that they are entitled to under the Act. However, this can only occur if two conditions are met. Firstly, the director must give approval for this arrangement, and secondly, the employer must agree to it. The director's role here is crucial to ensure that the decision to forego vacation is in compliance with the broader standards of employment law and is not unfairly imposed on the employee. Subsection 2 of Section 41 clarifies that even if an employee is allowed to forego their vacation, the employer is still obligated to pay the vacation pay. This means that the financial benefit associated with the vacation entitlement is still due to the employee, regardless of whether they actually take the vacation time off. The intention behind this is to ensure that employees are compensated for their entitled time off in one way or another, reinforcing the principle that vacation pay is a right that cannot be waived or disregarded by the employer. In summary, while Section 41 provides some flexibility regarding vacation time, it maintains strict provisions to ensure that employees' rights to vacation pay are upheld. Moving on to Section 41.1 of the Employment Standards Act, this section introduces provisions regarding an employee's right to receive written statements about their vacation entitlements. Subsection 1 of Section 41.1 stipulates that an employee has the right to request and receive written statements about their vacation entitlements. Specifically, they can request a statement after the end of a vacation entitlement year or a stub period. This statement must include the information that the employer is mandated to keep as per subsection 2 of Section 15.1 for a vacation entitlement year or subsection 3 of Section 15.1 for a stub period. These records essentially detail the employee's vacation time and vacation pay entitlements. Subsection 2 of Section 41.1 outlines the time frame within which the employer must provide these statements upon the employee's request. The employer is obligated to provide the statement either within 7 days after the request or on the first payday following the request, whichever is later. Subsection 3 of Section 41.1 addresses requests made during the vacation entitlement year or stub period. In such cases, the employer must provide the statement within 7 days after the start of the next vacation entitlement year or on the first payday of the next year, whichever is later. Subsection 4 of Section 41.1 limits the frequency with which an employer is required to provide these statements. An employer is not obliged to provide more than one statement per vacation entitlement year or stub period to an employee. Lastly, subsection 5 of Section 41.1 notes an exception to these requirements. If an employer pays vacation pay in a manner consistent with subsection 3 of Section 36, the obligation to provide these statements does not apply. This suggests that in cases where vacation pay is handled in specific ways, the detailed statements outlined in this section may not be necessary. In essence, Section 41.1 emphasizes the transparency and accessibility of information regarding vacation entitlements for employees, ensuring they are aware of and can verify their vacation-related benefits. All right, so that concludes our detailed look at Part 11 of Ontario's Employment Standards Act. These provisions are key to ensuring a fair balance between work and leisure, serving the interests of both employers and employees. Understanding these rules is vital whether you're an employee planning your well-deserved break or an employer managing vacation entitlements. If this video has illuminated the vacation-related aspects of Ontario's employment laws for you, please consider liking and subscribing to the channel. I'm Ryan Keeney, and as a lawyer in Ontario, my goal is to demystify these complex legal subjects with clear, accessible explanations. Your support is incredibly valuable and encourages me to keep producing insightful legal content. Remember to hit the bell icon for notifications about new videos. If there are any questions or specific topics you'd like me to address in future videos, please leave a comment below. Thanks for watching, and I'll see you in the next video.